Good afternoon. This is Sean Golding with Golding & Golding, here to talk about a issue that hits many taxpayers, especially when they're getting close to retirement or their family may be moving back to a foreign country, and that's whether they should renounce their U.S. citizenship or terminate their green card. When it comes to renouncing or terminating U.S. status, it's important to note that there are two aspects of doing so. On the one hand, there is the immigration, where we either require filing a Form I-407 if you're a green card holder, filing Department of State Forms 4079 to 4083 if you are a U.S. citizen. And then there is the tax implication. Are you a covered expatriate? Is there exit tax? Did you file your final return? Did you do your initial or annual expatriation statement, Form 8854? So there's a lot going on. It's a big decision. Let's walk through the basics. The first question is, are you seeking to avoid U.S. person tax status? Now, technically, you're not supposed to want to give up your U.S. status only for tax purposes, but most of the time that is an important aspect of wanting to terminate, even if it's unspoken. When a person is no longer a U.S. person, then they're not taxed on their worldwide income, right? Instead, they're just taxed on their U.S. sourced income. Instead of filing a Form 1040 to report their worldwide income, they file a Form 1040-NR to report their U.S. sourced income. It's important to note that it doesn't apply to visa holders. So even if you're here on like a B1, B2 tourist or L1, H1B, and you've been here for 10, 15, 20 years, that is not considered for exit tax purposes, for covered expatriate purposes, for expatriation. You have to either be a U.S. citizen or a long-term lawful permanent resident. The latter category essentially means that you've had your green card here for 8 of the past 15 years, and during that time, assuming you don't qualify for any exceptions, exclusions, or limitations, and during that time, you have not applied for Form 8833 treaty rights to be treated as a foreign person, because in any year that you've done that, that does not apply toward the 8 of 15 years. Another thing to keep in mind, for that 8 of 15 years, it doesn't require 8 full years. For some taxpayers, they think, well, I still want to come to the United States and visit, but I don't want to have U.S. person status. So you can still obtain a visa, or you may qualify for a 90-day ESTA, but depending on what country you're from, they may have like a treaty visa. You can get the B1, B2, which I believe lasts for 10 years, and you can go 6 months in, 6 months out. You come here as a student or for whatever reason. So you're not prevented from coming to the U.S. There's no list. There's a fear-mongering out there, as in every aspect of international tax, but there's no like black book list of people who can't come in just because they gave up their U.S. status. So let's talk a little bit about the difference between renouncing U.S. citizenship versus terminating the green card. When you're giving up U.S. citizenship, it's more complicated because you're a citizen, and giving that up, there's more that's required, right? You have to file several forms. The Department of State Forms, DS, they start at 4079, they go to 4083. Typically, you have to do it in person outside of the U.S. at one of the consulates or embassies. You can't do it in the U.S. There is an extensive waiting period at some of the locations, although that has gotten better since COVID is kind of sort of wrapping up. And you don't necessarily need to do it in the country that you're a dual citizen of. But another thing to keep in mind is when you're going to renounce your U.S. citizenship, you have to have citizenship in another country. For some people, it's easy. They're already dual citizens or they have lineage at a different country. It's easy to get it. For other people, they may want to consider obtaining a golden visa. There's residency by investment programs and citizenship by investment programs, RBI and CBI, where you can essentially buy citizenship so that you have that second citizenship. Sometimes, depending on where your second citizenship is, there may be a waiting period between the first time you go in for the interview and when they approve it. They may make you come back for a second interview. Giving up the green card is different. I mean, it's relatively simple. You just file Form I-407. You used to be able to walk it into one of the locations and kind of hand it off, and they don't have to accept that anymore. But some locations still do. Otherwise, you just submit it. I believe it's to Vermont. You put your email address on there, and then normally within 3 to 12 weeks, you'll receive a confirmation that it was received and processed. The term that they use in terms of when is the last day for U.S. tax purposes is the day it was filed is the expatriation date. So assuming, let's say you sent it in March 1st, you don't hear until June or July, March 1st should be the day for tax purposes. Now moving on to the tax implications. When a person is a U.S. citizen or a long-term lawful permanent resident, in the final year, they typically will have to do a dual status return. Part of the year, they're a U.S. person. They file a 1040. They report their worldwide income. The other part of the year, they file a 1040 NR, and they only report their U.S. source income because they're no longer a U.S. person, especially for taxpayers who are earning abroad, self-employed or working for a company and earning significant amounts of income. It's nice to not have to report that for their worldwide income. They have to do the Form 8854, which is the initial and annual expatriation statement. The level of complexity and anger that this form will cause you will depend on whether you're a covered expatriate or not. So you're a U.S. citizen or a long-term lawful permanent resident, you have to do the 8854. There's 3 tests to determine whether or not you're a covered expatriate. There's a net worth test, a net average income tax liability test, and the 5 years tax compliance test. There's exceptions and exclusions and limitations depending on how old you are doing this, if you've had dual status and you're a dual citizen and living outside of the U.S. and things of that nature. But there's 3 main tests to determine if you're a covered expatriate. So if you're a U.S. citizen or a long-term lawful permanent resident, then you do the 8854. You do the 8854 and you're a covered expatriate, then you have to determine whether there's an exit tax or not, and that's a whole nother presentation, right? But there's mark-to-market gain, there's specified tax-deferred accounts, eligible deferred compensation, ineligible deferred compensation. You get a certain exclusion amount for the mark-to-market, and there's lots of nuances when it comes to preparing that form, depending if afterwards you're going to own a trust in the U.S. or you have certain deferred compensation. You might have an annual filing requirement for the Form 8854. You may be able to put up a bond to avoid the exit tax, but those bonds are typically very expensive. So if you're planning on doing this, it's important to plan beforehand, if possible, to try to avoid the exit tax. Maybe you're a green card holder, your wife is a citizen, and there's the unlimited exception in terms of transferring assets to him or her, depending on your relationship and the facts and circumstances. One of the most important aspects for taxpayers is making sure they are 5 years tax compliant before getting into compliance and filing the Form 8854. And before expatriating, technically, because once you file the I-407 or you go through renouncing your citizenship, from a expatriation standpoint, you've done the act. Now, the taxes are typically filed in the subsequent year, but before you do any of that, it's important to be tax compliant. If you're not, then there's various programs that you can submit to in order to get into compliance. This is super crucial for taxpayers who would only be a covered expatriate because they are not 5 years tax compliant. If they're willful, there's the VDP program. If they're non-willful, then there's various other programs to streamline procedures, delinquency procedures, and possibly reasonable cause. We got a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golden with Golden & Golden. Thank you for your time. Enjoy the rest of your day.